I'm attorney David Villa, and this is your Connecticut DUI case guide. The night of the arrest. Police observe a vehicle. Most DUI arrests begin with a traffic stop for a motor vehicle violation. Some common triggers: swerving, speeding, broken equipment, expired registration, and accidents. Officer approaches and looks for signs of impairment, odor of alcohol, slurred speech, glassy eyes, or open containers. You are not required to answer questions beyond identifying yourself. Anything you say will be used against you. You are required to provide your license, registration, and insurance. At this point, the officer is building a case. Everything is being noted and will be in the report. Field sobriety tests, FSTs for short. An officer will ask you to step out of the vehicle and perform field sobriety tests. You are not legally required to perform field sobriety tests in Connecticut. These tests are designed to generate evidence against you, not to help you. The three standardized tests are the horizontal gaze nystagmus, or HGN, the walk and turn, and the one-legged stand. Scoring is entirely negative, meaning that you cannot gain points, you can only lose them. An officer who has done these tests hundreds of times is judging your first attempt ever. Medical conditions, footwear, road service, lighting, and nerves all affect performance. None of that gets factored in. Good news is that results are subjective and can be challenged in court. Chemical testing, the breath or blood test. After arrest, an officer will request a breath or blood test. Connecticut has implied consent law, ergo, by driving on CT roads, you have already consented to the chemical test. Refusing the test is your right, but it carries automatic and serious DMV consequences. Refusing does not mean you're avoiding a DUI charge. You can still be charged based on the officer's observations alone. If you take the test, results of .08 or above trigger both criminal charges and DMV action. If you take the test and blow below a .08, you can still be charged if the officer believes that you're impaired. The intoxilizer machine used in Connecticut has known calibration and maintenance issues. These can be challenged in court. Arrest and booking. You're transported to a local police department, processed, fingerprinted, and photographed. Your license is automatically suspended for 24 hours from the time of the arrest. This happens immediately, before any DMV hearing or court date. This also means that you cannot drive yourself home from the police station. A sober person must come and get you, or you may arrange for alternative transportation. Your car will likely be towed from the scene, and tow and storage fees begin immediately and accumulate daily. Do not drive to get your car the next morning thinking the suspension is cleared. Confirm the 24-hour window has fully passed before anyone hands you the keys. Release that night is possible, however, that depends on the charges, your record, and whether or not someone can come pick you up. If released, you will be given a court date. Missing that court date is its own criminal charge. If not released, you'll wait in lockup until arraignment the following morning. Two separate cases that now exist. A DUI arrest immediately creates two completely separate proceedings running at the same time. A criminal court case, the state of Connecticut versus you, and a DMV administrative hearing, the Department of Motor Vehicles versus your license. These are independent of each other, and you can win one and lose the other. They have different standards, different timelines, and different consequences. Both must be handled. Ignoring the DMV side is one of the most common and costly mistakes people make. The DMV administrative process. Act immediately. You only have 7 days from the date of the DMV notice letter to request a hearing, not 7 days from the date of the arrest. The notice is mailed to you by the DMV after the arrest is processed and filed. Depending on mailing speed, the letter may arrive with only 1 or 2 days left on the timeline. Don't wait for a letter to hire a lawyer. By the time it arrives, you may be out of time already. If you miss a 7-day deadline for any reason, you automatically lose your license. There is no extension and no appeal of the missed deadline. Hire counsel immediately after arrested so your lawyer is watching for the notice and can act the moment it arrives. What the DMV looks at. Number 1, was there probable cause for the stop? Number 2, were you lawfully arrested? Number 3, did you refuse the test or did your BAC test at .08 or above? And 4, whether proper procedures were followed. The DMV suspension periods. For a first offense with failed test, a BAC of .08 or more, you'll get a 45-day suspension. For a first offense refusal, it's also a 45-day suspension. For a second offense and further offenses, longer suspension periods may apply. Suspensions begin 45 days after the arrest date, regardless of where the criminal case stands. Now, what can a lawyer do at the DMV hearing? They'll cross-examine the arresting officer, challenge whether proper procedures were followed, challenge the calibration and maintenance of the breath test equipment, and challenge the lawfulness of the stop itself. A win at the DMV hearing means no license suspension, independent of the criminal case. Your license after a DUI arrest. You cannot drive at all during the suspension period, full stop. Driving on a suspended license is a separate criminal charge under Connecticut General Statutes 14-215. After the suspension period, reinstatement requires, number 1, payment of reinstatement fees to the DMV, 2, proof of insurance, an SR-22 filing is required, and 3, installation of an ignition interlock device, or IID for short, in your vehicle. Let's talk about the ignition interlock device. It is a breathalyzer installed in your vehicle that you must blow into before the car will start. It is required for 1 year after reinstatement for a first offense, and required for 3 years for a second offense. You pay for the installation and monthly monitoring fees. Cost runs about $75 to $100 per month. The device requires rolling retests, meaning it will prompt you to blow again at random intervals while your vehicle is running. You must pull over safely to complete the retest. You are not expected to blow into the device while you're actively driving. Failing to complete a rolling retest when prompted is treated the same as a failed test and gets reported to the DMV. A failed or missed rolling retest can result in further license suspension. You must use a DMV-approved IID vendor. The IID requirement applies to every vehicle you drive, not just the one you were arrested in. Work permit and school permit. The hardship license. If your license is suspended, you may be eligible for a special operator's permit, commonly called a work permit or hardship license. This allows limited driving during the suspension period for specific purposes. Who qualifies? First-time offenders in most cases. Prior DUI history affects eligibility. It covers driving to and from work and driving to and from school or education programs. What it doesn't cover: medical appointments, going to alcohol education or treatment programs. You must arrange alternative transportation for those trips, or leisure driving, like errands or driving whenever you want. You must apply through the DMV. It's not automatic. The permit requires an IID be installed in your vehicle even during the hardship period. Violations of the permit conditions can result in full revocation of driving privileges. Apply for this immediately. There is a gap between when your license is suspended and when the permit takes effect if you wait. Arraignment, the next business day. This is the first court appearance, usually the morning after arrest. A judge reviews the case and sets conditions of release. Charges are formally read. In Connecticut, a DUI is charged under Connecticut General Statute 14-227 alpha. There are 2 ways the state can prove a DUI. 1, per se. That's a BAC of 0.08 or above. The number alone is enough. And 2, common law. The state must prove that you're impaired to a substantial degree. No BAC number is required. Both methods can be charged simultaneously. Court process after arraignment. There will be multiple court dates. These cases don't resolve quickly. There will also be pretrial conferences where the prosecutor and the defense counsel negotiate. Evidence is reviewed: dash cam, body cam, officer reports, breath test records, calibration logs, and 911 calls. Defense investigation looks at maintenance records for the intoxilizer, officer training records, and the chain of custody for blood samples. Prosecutors can't simply drop a DUI charge without formal justification. Connecticut law requires them to state on the record in open court exactly why they're dismissing or reducing the charge. This means their decision is public, permanent, and tied to their name and reputation. Prosecutors are therefore extremely reluctant to reduce or dismiss DUI charges without a compelling legal or factual reason. A lawyer's job is to find and build that reason. A bad stop, a faulty machine, improper test administration, or constitutional violations are the kind of things that give a prosecutor cover to act. Without a strong legal argument, don't expect the state to walk away from the DUI charge. Ways the case can resolve. 1. Impaired Driver Intervention Program, or IDIP. Connecticut renamed and expanded the old alcohol education program. It is now called IDIP to cover both alcohol and drug-related DUI cases. You complete a series of intervention classes and the case gets dismissed. IDIP isn't available to everyone. A person must be a first-time DUI offender and they cannot have used the program within the past 10 years. They can't have used AEP or IDIP in Connecticut or a similar program in another state within 10 years. The BAC level and circumstances of the arrest may affect eligibility. And a commercial driver's license or CDL holder faces additional restrictions. The use of the IDIP program does not equal an admission of guilt. After successful completion, the case is dismissed. Even with IDIP, the DMV suspension still applies. The program is independent of the DMV process. You'll be eligible to use IDIP again after 10 years. The use of IDIP is not a permanent bar to future use. Number 2, a plea agreement. You plead guilty to a DUI or reduced charge. Connecticut prosecutors face legislative restrictions on reducing DUIs, as we've discussed. They must make a public statement explaining any reduction. This may involve probation, fines, community service, and alcohol treatment. It creates a criminal record. This could affect your employment, professional license, immigration status, and CDL holders permanently. Number 3, dismissal. Charges are dropped based on legal defects, unlawful stop, improper testing procedures, or constitutional violations. It doesn't happen just because the client wants it to. And number 4, trial. Jury or court trial. The state must prove guilt beyond a reasonable doubt. The defense attacks the stop, the field sobriety test, the chemical test, and the officer's conclusions. Expert witnesses on breath testing science can be used. Penalties, if convicted. First offense, jail. 48 hours, mandatory, minimum. A judge can suspend and substitute for 100 hours community service. Fines, 500 to 1,000 plus surcharges. License suspension, 45 days, followed by 1 year IID requirement. Probation, up to 2 years. Alcohol assessment and treatment may be ordered. An SR-22 insurance filing required for reinstatement. Penalties if convicted second offense, within 10 years. Jail, 120 days mandatory minimum. 30 days must be served, balance can be suspended. Fines of $1,000 to $4,000, license suspension 45 days, followed by a 3-year IID requirement. Permanent mark as a second offender. This affects future cases dramatically. And enhanced scrutiny from prosecutors and judges. Here's some collateral consequences we should discuss. Employment. Arrest records are visible. Many employers ask about DUI convictions specifically. Professional licenses. Attorneys, nurses, teachers, commercial drivers, pilots may face licensing board consequences. CDL holders. A DUI conviction effectively ends a commercial driving career. Federal law is far stricter for CDL holders. Immigration. DUI convictions can affect visa status, green card applications, and citizenship. Insurance. Rates increase dramatically. SR-22 filing required. Some carriers drop clients entirely. Out-of-state driving. Connecticut suspensions reported to other states through the Driver License Compact. Federal employment and security clearances. DUI arrests and convictions must be disclosed. College applications and financial aid. Some programs may ask about a criminal history. The 10-year look-back period. Connecticut looks back 10 years when determining whether a DUI is a first or second offense. A DUI conviction from 11 years ago does not count as a prior. A conviction from 9 years ago does. This affects mandatory minimum jail time, fines, license suspension length, IID duration, and IDIP eligibility. The 10-year clock runs from conviction to arrest date on the new case, not arrest to arrest. Prior DUI dispositions from other states count under Connecticut law. Case resolution. Dismissal after IDIP completion, best outcome, no criminal record. Nolli proseque, also known as nollied. Prosecutor declines to prosecute, but it stays in your record for 13 months. Acquittal out of trial, not guilty, case closed. Conviction, sentencing, permanent record, all penalties apply. After dismissal or nollie, expungement may be available. License reinstatement requires fees, SR-22, and IID installation. It doesn't happen automatically. IID removal must be applied for after the required period, does not come off automatically. Here's some key points to leave you with. You have 2 cases, criminal court and the DMV. Both must be handled. You have 7 days from the DMV notice letter to request the DMV hearing. Do not wait for that letter to hire a lawyer. Apply for your hardship license immediately if your license is suspended. Do not drive on a suspended license, it makes everything worse. Do not drive yourself home or to retrieve your car in the first 24 hours after arrest. Do not talk to the police without a lawyer present. The IDIP program is a one-time option every 10 years. Think carefully before using it. A DUI moves fast on the DMV side. Hire counsel immediately, not the week before court. That's it. Once again, I'm David Villa with Ruane Attorneys. If you're facing charges in Connecticut, give us a call for a free case evaluation and we'll tell you how we can help.